I'd like to call the meeting to order for September 12th, 2024 Board of Adjustment meeting. Madam Clerk, would you call the roll, please?
Stephen Craddock,
Here.
Troy Breathwaite,
Present.
Robin Kane,
Here.
Shay Balance,
Here.
Kathy Bontemps. Here. Sam Miller,
Here.
Justin Hayslip.
Here.
All righty.
5 regular.
We do have a quorum with 5 regular members and 2 alternate members present. Are there any changes to the agenda?
See what they do on the screen.
May I have a motion to accept the agenda?
Make a motion to accept the agenda as written.
Do I hear a second?
Second.
All those in favor say aye.
Aye.
All opposed say nay. Motion carries unanimously. And now approval of the minutes for the June 19th, 2024 meeting. Are there any questions or comments about that, about the minutes? Hearing no questions, may I have a motion?
I'd like to make a motion to approve the minutes from March 14th, 2024,
I believe you mean June 19th.
June 19th, 2024.
I'll second that.
All right, all in favor say aye.
Aye.
All opposed, nay. Motion carries unanimously. In accordance with the State Government's Ethics Act, it is the duty of every board member to avoid conflicts of interest. Does any board member have any known conflict of interest with respect to any matters coming to the board tonight? If so, please identify the conflict and refrain from any participation in the particular matter involved.
I do not.
None here.
Hearing none, we have no disqualifications. Old business, Board of Adjustment 22-01, Misty Young draft order. Review of the draft order related to the Misty Young notice of violation appeal.
So in your packet, you have my proposed order based on the hearings that occurred in this matter, the record. And if you recall, the board was very specific that you wanted to, based on the remand order, that you were going to review the record. You were also going and use the record and of the prior hearing and all the contents that went up on appeal, in addition to whatever other information was received at the hearing on, for additional information on those, specifically on those factors. And so this order is a reflection of the things the board talked about in your deliberations and in your questions and all the things leading through both the first hearing and also review of the record and then review of the minutes from the last proceedings. And the notes I took from your questions and deliberations from that hearing in June as well. And so the county submitted handwritten changes. Some of them are just typos, and then some of them are, there's more kind of content changes. And then the appellant, Miss Young's attorney, submitted a blanket objection without identifying anything specifically. And that letter's also been included in your packet. I will note he's taken the position that the order I drafted mischaracterizes the testimony and the record. I certainly disagree with that, but without knowing what specifically he felt that I mischaracterized, except maybe the entire thing, I don't know how to address any of his concerns or to reference any more than I already had what was added to or adjusted in the order. As I discussed with you guys in session at the end of this hearing, you'll see at the end of the paragraphs, if there was no kind of parenthesis with a reference to where I found it, it was from the prior order. I did restructure the order a little bit such that it maybe addressed some of the questions that Judge Tillett had based on what did the board consider about these things and what did the board find about these factors in the procedure and the process, other than just kind of walking through it. So I added additional findings, and anything I added, I put a reference to where it came from. So it certainly would have been helpful for me to have some specific information from Ms. Young's attorney about what they did not agree with, such that I could have, given you that information to consider and
Didn't
as
he
a
include,
counter.
didn't he include an example that he thought was, he
did.
said, a couple of the factors, and I think one of them, he made reference to the 10th factor, which I think is, subpart J, which I think we found was one that was not relevant.
So he said the 10th factor said part J, parking requirements, turnover and generation ratio, and the number of spaces required per unit area or activity. So I put that under that, let me get to that section. Parking requirements, turnover, generation ratio of a number of spaces provided. There was testimony in the prior hearing from the record, and this is something that the board asked questions about and something that the board discussed, that said, so it was actually the record, so like the printed transcript. So if it said RP, I got it from the printed transcript, and it was the page numbers referenced, 116, and that's where that information came from. It was that she operates a business in the town of Duck where she could rent Jeeps, but she chooses to store the Jeeps in and rent from Corolla because her clients are bringing her Jeeps to Duck for clients to rent from Corolla would defeat the purpose of the clients using them in Corolla on the 4x4. I believe it was in a response actually to one of your questions, Troy. And so because that question was asked, that information was provided, I thought that factor went under that factor, but we can move that to other relevant factors. I put like kind of a sub paragraph there that said that. I also, in light of his letter, which again didn't give me any specifics other than that one, I changed if you look at paragraph 35, it initially said the following factors are relevant and were properly considered by staff pursuant to UDO section. I realize that maybe that was not specifically set forth, that every single thing underneath that factor that I listed there was specifically stated by staff in the limited hearing, but it came from the record. And so Judge Tillett's remand order said that your new order could be from the record only. You could receive additional testimony regarding that, and you could also confer with counsel about which route they wanted to go. And this board opted to do all of the above, which was rely on the record, have a limited hearing, and you also did allow counsel to provide some input about the process going forward. And so I reworked that to say, I did a new paragraph 34 that says staff properly considered the standards and factors set forth in UDO section 10.4.1D2. And then the paragraph 35 now says the following factors are relevant, period. And then it goes down so that this is what you, assuming you agree, which I think you do, but these are the things that were in the record to support the factors that staff testified to. Regarding that one with the parking requirements, if you do want that finding based, because that was in response to a board question, I can simply move it down to paragraph. Give me just 1 second. I'll get there. It's now 36. Additional factors relevant included. And so I added additional things that the board had previously touched on or discussed or evidence from the record to support that. So that's, if you look at what would now be 36, it says additional factors relevant included. And then you went from there. So we can move that one down so it doesn't appear as if it was to J, which the testimony was that wasn't an applicable factor. So I don't have a problem moving that. And again, if I had more specifics from them, those are the kind of things we could work through, and I could try to understand and help the board with additional year findings. So I can move that if you would like me to do that.
So does the opposing attorney have an obligation to point out specific things that he objects to, that they object to, or is that just maybe an opportunity to provide another, avenue for appeal again?
So I don't know that there's necessarily an obligation for him, like any sort of legal obligation that he has to spell out his objections other than what he's clearly is. He objects to everything. I'm saying it would have been helpful for us to narrow issues that could be raised on appeal if we, like, for instance, that one. I understand. I mean, I'm writing this order based on what the board has been through for the last, 2 years at this point. And so I realize, okay, sure. I realize reading that, maybe it indicates or would lead, if you're a fresh set of eyes reading it saying, oh, it sounds like staff considered it, but she testified that she didn't. Well, I can move that around. And if the board finds that information that you received in response to a question was relevant to your decision as another factor in your consideration, I'll move it down in the order. I can rework the wording so that it properly reflects the board's intent. So I don't think he has I can't think of a legal, like a rule of procedure that requires that. So, I think he just is blanketly objecting to it in its entirety, and I assume he'll raise those issues, his issues with the order in whatever version comes out of your meeting tonight on appeal.
So this whole session is to prepare for an appeal by.
Well, this whole session is to finalize your order. So I don't know if you guys remember, we did this with the campground.
Yeah.
Because it was such a long, drawn-out, very extensive hearing and a lot of back.
That was a long meeting.
It was a long meeting.
1 o'clock in the morning, wasn't there?
It was, and
Don't remind me.
because it was one of those issues, it wasn't there was a lot of contested facts and issues. I brought the order back to you again that time and said, give your comments. Both attorneys provided their proposals, and you made a decision about what you were going to do. So I think that for now, I think it might be helpful if we just kind of go. The county provided comments, so I think it would be helpful if we kind of work through those, and you can say yay or nay, and then I know what to change or not change. And then I can explain, if you have a question about any particular thing about why this is there or not, and we can kind of go from there. And then,
So which one of these, so the first order that's in the packet, the clean one,
yes, that's my initial that's my initial
that's the
order.
initial one, and then the second one is the one with the
Markup.
It's the markup
markup.
from the county.
from the county. Okay,
Yes.
gotcha.
And so, let me just get my highlighter. So I'm going to highlight what you say, if you say yes or no, and whatever modifications. So in regards to, obviously, that first one, the board, there's a typo, but it doesn't show up because
So we'll just kind of go page by page through
Yeah,
the second.
that's
what we'll do.
Yep.
that's a good idea.
And so that first one, it says, obviously the board, that's a typo. I'll fix that one. Where did it, let me make sure I'm on the same also. So the one in the packet is different also.
So we're working on this one on page 23.
That's right, page 23.
Okay.
Okay, so the first thing said the board, was there an updated one? Because the one that was in the link says the board. Okay.
Is there something that we?
No,
wanna
it's okay,
say
I'll
the
follow
board?
along on this one.
Just in parentheses, yeah.
Yeah, what's wrong?
Oh, here we go. Okay, I'm sorry, I was on the wrong page. Okay,
Just kind
I've been in court
Putting it there, then the rest
all
of the
day
board.
today, so I
can just say-
apologize.
Yeah.
of, right,
Okay,
Take that out?
I don't know.
Did you want to take the board out?
no.
Oh, okay.
I was on the wrong page. I thought I was on the next page where there is a typo on the word board, and I was like, that's clearly a typo. The planning and inspections department, I don't have any issue with that. I had that with, probably from another order where the department is what it is, so I don't have anything with that. It changed? Okay. Okay.
Oh, it
See,
did
there.
change?
I had no
Okay. Yeah,
idea.
see,
So,
Now we know.
the next one, as described herein, that's no problem. I don't have a problem with that. The honorable and not honorably, obviously, that's that's just a typo.
We don't want to make the judge mad like right on the first page.
So this next one, number 3, the decision of whether to hold a hearing regarding these factors or rely on the record, evidence, and/or arguments is left to the Board of Adjustment in consideration with the parties. And let me pull that letter. I took that specifically because I don't think the or goes right there because it makes it sound like it was one or the other, and that's what the board had to decide, but that's not what Judge Tillett said. You could do one of these, all of these. It says and or, and so I don't think the or goes there, and I had it
So they're saying we should put or in there, the decision
correct,
of whether
but
to hold a hearing.
his
Inspectors.
his order. Let's see, I'm looking at my January.
I'd leave the
packet.
or out because it doesn't read right.
It doesn't,
it
it
doesn't.
doesn't.
You know, it should say the decision was based regarding these factors, and the first one is rely on the record, that's 1. 2, evidence. 3, and/or
Yep.
arguments left to the board in consideration of parties or stipulations between them. So that first change of that or should not be there.
Correct, and I just pulled the order, his Judge Tillett's order, and there is no or. I typed that specifically as his order read.
Okay.
But I realize when you're proofreading this, if she didn't have the benefit of having that order right there and knowing where it came from, that's, what I would say to that. Okay, so now I'm on page 24, but page 2 of the order. Board, that's the one I was looking at just a minute
Freaking
ago.
out about it, yeah.
Yes. And then the next addition about the county sent the board a letter. This is correct. I mean, there was a letter sent to the board, from the county, and I just didn't add it in the procedural history. It would be appropriate to add that.
Okay.
Okay, and then in number 5, it says the board voted she struck also. Again, I think that should remain, the also should remain, because the board voted to also utilize that option to, pursuant to the remand order.
I wasn't here, but I would say I would agree, because it says that, look, we considered this and this and this. We did everything you said.
Correct. So then that brings me to page 3. She struck the UDO parentheses. I mean, that, I don't have a problem with that. They added single-family residential Outer Banks.
Right.
If that's the description, I don't have that's just a clerical correction.
You gotta change the summary to, or your acronym there as well, the SFO.
I think it's SFO, but,
There's two of them. If you look in the zoning handbook, it calls, because we have single-family mainland, and we have single-family Outer Banks as well.
all right, let me pull
The
it up.
mainland one is SFM.
Yeah. So I don't know if it's SFO, right?
Yeah, that is correct.
Just
Okay.
make sure it matches is the big thing.
Well, let me look at it right now, since we're here. Let's see, I'm in the ordinance, give me just a moment. Oh, I'm not on the internet.
Chapter 4.
Let's see if I can connect to the guest. Perfect. Okay, that was easy enough. Zoning districts, it's in chapter 3.
Yeah, it is SFO.
Yeah.
That's right.
Okay.
Yep.
Okay. So that's right. So I'll fix that description, the SFO. And then, all right, so we'll go to page 4, Monterey. I apparently spelled that wrong. I will correct that. Let's see.
What is the edit on paragraph 10 on page 20, page 3?
Yeah,
That is the residential Outer Banks. So I put single-family outer, and I did not put Outer Banks. I just put SFO.
Says
It's single-family
outer-
residential Outer Banks is what it's supposed
Single-family
to be.
residential Outer
Yeah.
Banks.
Yeah, but haven't we already defined that as SFO zoning district in paragraph
Just the
5?
description previous to that is just incorrect with the.
Yeah, but I'm
see.
saying,
Oh, I
usually
did.
once you
Yes,
use
I did.
for them once, you don't
Zoned
redefine it again.
FSFO. So actually, you're right, that would be just the SFO, because I do reference the FSO zoning district. So that should just be changed to, which is zoned FSO zoning district. Mhm.
Were there 2 R's in Monterey?
I can't tell.
This-
AY.
I just
It's
looked it
AY.
up. It's AY, yeah.
That's not the Monterey in California then.
I guess not, because I was spelling it differently, but anyway.
Is that where she moved them to when she moved out of Hampton?
Um,
Because that's still Currituck County.
no, Monterey was the, oh, yes, that was,
Yeah.
well, yes, that's where they were moved to.
So she's
At that
still not in
point.
compliance.
Well, there was no NOV issued for that, so
Missed opportunity.
that's all I can say.
I was hoping she moved them down to Duck and then we'd be, okay.
I don't know where they are at this point, but
Have we ever identified what her business in Duck is?
no, that was not,
Refused to answer it.
that was not provided in the record.
Okay.
It's not part of our,
I imagine
Information.
planning
Well,
will
I
at
asked the
some
question, and
point
she refused to
define
answer it, so.
what ride sharing is at some point.
probably.
Or the state.
Yeah.
Okay, so the next one was 18 and 20 were similar repetitive paragraphs. I don't have any I referenced the same citation, so I obviously felt like it was important to, but that is, I'll leave that to you to pick which one, and,
It seems like the second one reads a little
Yeah.
better.
That's what I think reads a little bit better. If it covers all the issues.
all right, so we'll just mark out 18 and leave 20?
Or maybe even the word enough. Maybe it should be similar to, instead of similar enough.
Was similar to, okay? So still mark out 18?
Yeah, it's
Yeah, I would-
virtually the same thing.
yeah,
but
they're
20
basically
is
the
They
same
are,
thing.
they are the same. They are pretty much the same thing.
Okay.
And they reference the same record page reference.
Does your, are you using Word for this?
Yes.
So I guess if you take that out, it's gonna renumber everything the rest of the way. So we're gonna make sure we don't have any references to different sections that,
There, I don't reference any paragraphs.
oh, okay.
In the order.
Yeah.
Or paragraph numbers.
Yeah.
When I was reading it to you, but I'm just gonna track with you on this, and I'll use my handwritten edits to do the final draft to email.
Okay.
So that brings us to page 5. The use of the word that and I'll tell you, when I first started practicing civil law many, many moons ago, my mentor and later law partner, John Morrison,
He's a great guy, by the way.
he is a great guy, super smart. I learned so much from him. He started taking my letters and orders and everything. And John is a wordsmith. He's probably read every book that's ever been published 10 times. And he said, I'm going to start editing for you so that you can, learn that there are words that you don't need. And, I didn't realize how many times I put that in a in a sentence. And maybe to the extreme now, I remove the that's and the us and the ands and the things, maybe to a fault. So that's stylistic. I'll be happy to add it. You tell me. I have no issue either way with that. But that's why there's a lot of that's and us that are gone.
I don't know,
And
it's yours.
John's a heck of a storyteller also.
He is.
You want to know something, you just ask him, he can tell you.
He is.
Yeah.
Yep.
Yeah.
So in that paragraph 22, I had 2 section marks there because I referenced 2 sections of the ordinance. And then I do think the is appropriate, allowed in a particular
I do.
zoning
I do
district.
too.
Provides staff, may interpret, provides staff. So, and then paragraph 25, they moved the word use, the use automotive, sale and rentals. I don't have an issue moving it till after. That's
Sure.
no issue there.
Yeah.
It is repetitive that I said is defined or defines in that paragraph 26. 27, this would have been the definition of rent that was testified to, and I might have taken items that might be related are, that might have just been staff's verbiage. I don't know from the transcript if she was reading the definition specifically or she was kind of commentating. I don't have any heartburn about leaving it or taking it out, but I can't tell if it was part of the definition that she read from the record.
I think the changes are fine in 27.
Yeah, I don't have any problem with
Okay.
those.
So I will make all those.
Looks fine.
All right. Which brings us to 34. What's 34? The following factors are relevant and were properly considered by staff pursuant to. And this is the thing we were talking about initially, that based on Mr. Crook's letter, I went back. Obviously, I would never propose something that was contrary to the record and evidence, and wrote this in good faith for the board. But I did go back to review and read it from a different set of eyes, maybe. And so I did rework that paragraph as we discussed earlier. So now 34 will say, staff properly considered the standards and factors set forth in UDO 10.4.1.d.2. And this is properly follows 33, which talks about purpose and intent statements concerning the district, the character and the use types allowable in the district, and all relevant characteristics of the unspecified use, including but not limited to those set forth in subparagraphs A through M. And so this is 33, and if you recall from your deliberations, you guys talked at great length about that it has to be read in its entirety, that you have to read this section and apply all the proper related sections. And so that's why I put that paragraph, and then this next one, staff properly considered the standards and factors. So then now, to make sure that it's clear that this is what the board found regarding these factors, I changed now it's a new 35. It says the following factors are relevant, and then we'll go from there. So that 34 will now be a 34 and 35, just to separate it out so that it's clear. You're not contending that staff found every single thing on that you use the record to determine these things.
So in that section, we say in paragraph 33, we say characteristics of the unspecified use, including but not limited to those set forth in subparagraphs A through M. But we're not listing out everything in subparagraphs A through M here, right? So this
Correct.
next section, 34, is only listing those factors that were considered
Relevant.
relevant. And then in 35, we list the additional factors.
Right. So Judge Tillett's letter to council and his order was that specifically the court wants to hear about or see findings on these factors, including but not limited to. Like, this wasn't an exclusive list. And so things that the board considered relevant to affirm the decision of staff. So that's why I titled it other relevant factors. We can change it to other relevant considerations, but that's why I put that, because those were things that this board had kind of keyed in on, and also other things that were in the record, as you said, go in the record and pull out those things. And so that's why those are there.
Right. I think what was kind of throwing me a little bit is that we seem to be referencing D2, section D2, 10.4.1 D2 of the UDO, and it lists the subparagraphs with the characteristics in subparagraphs A through M of that section of the UDO, correct?
But it says, so the 10.4.2 D2 says all relevant characteristics of the unlisted use, including but not limited to the following. So the UDO gives guidance A through M, and then, but it says including but not limited to, which is consistent with Judge Tillett's order. But I can fix, in regards to the, it says that the, in it says 10, UDO, so I'm looking at paragraph 33, UDO 10.4.1.d.2 requires the director to consider the purpose and intent statements in the UDO concerning the zoning district, character, the use of the types allowable in the district, and all relevant characteristics. And I put, I italicized relevant because the board repeatedly said, relevant characteristics, only the
Right.
relevant
Some were,
characteristics,
some
not
weren't, yeah.
every single one you had to review. And unspecified use, including but not limited to those set forth in subparagraphs A through M. I can say A through M in the UDO paragraph referenced above or something, so there's not confusion about.
Yeah, because
follows.
because I think what follows makes it look like you're gonna next go through A through M, and it stops at G.
Okay.
Right. And I don't know if A through G that we have here in paragraph 34 corresponds to subparagraphs A through G in the UDO, or if they're just numbered that way because of
I understand. I can fix that.
sequentially we're going through.
I can fix that.
I was thinking about
Requires
that
the
as well,
director to
with the
consider
G
the-
stopping instead of going all the way to M.
Yeah, and then when we get to 35 on the additional factors, it starts over at A.
Yeah, that's sort
is
of
different.
confusing.
Material set forth in.
But as she was saying, 35 is what was in addition to what the UDO required.
Right.
A through
Is that right?
M of the aforestated UDO.
And I don't know if it would make a difference to lay out all of the factors, A through M, and then we could specifically put in which ones we said were not relevant.
Sure, I can do that. That's no problem.
It's sort of confusing when when it says A through M and then it's G.
That's fine. I'm fine to do that. Let me just, so then I won't fix that paragraph 33. I'll just go down and do A through M.
Yeah, and then
That-
the ones that we found not relevant, we could just say that was found to be not relevant by the board or.
Sure.
And A through M will be in paragraph 34.
Right,
That's section 34.
Right.
rather.
Well, yes, but it'll be the new 35,
Right.
but yes.
right.
Yeah, because we gained a number.
Yeah.
Yes, you did. Okay, so, but for purposes of what you're tracking, we'll be on 34A. And also because this has been restructured and now listen, this is your order. You can change it however. I was trying to structure this based on the remand order. I kept all of the prior order and then added to it based on, so if there's anything else that you found on your review of the record, if you agree based on reviewing the order that these were things you want added, if they're not things that you did not consider or did not find relevant, then you tell me, we'll strike it. But again, these are things that I found based on your discussion, your questions, starting from the first hearing all the way through. So the first one, and let me just switch back. The volume, so A is properly noted. It is the volume and type of sales, retail, wholesale, et cetera. And so you'll see if you'll just, I'm sure have already seen this. If you have any changes to outdoor space, I don't understand that change. Do you know what she meant by that one?
I think she said that it looks like that there should be a space between outdoor and tour.
Right.
It looks like it's
There
one
is a
word, but I think
space.
there is a space there.
There is a space, so
It
that's
looks like there's a space.
outdoor
But it's not very
space tour.
large
Let
like
me look at the record, page 35 that I.
You people that can read this print without glasses are not normal.
What?
I'm saying these people on here that can read
Okay,
this print
so
without
I
glasses are not
have,
normal.
what did I put up here?
Went to get my eyes
Outdoor tour
lasered
operator license.
10
So
years, and my
Looks
eyes
like about a half a space to me.
I have on page 35 of the transcript from the hearing. So you see I referenced that paragraph there. It says record page 35. The statement was, and this is line, and I'm trying to document everything because I know it's going on appeal, so I'm probably being a little more anal retentive than normal, but on page 35 of the record, line 18 and 19, it says, I spoke with her earlier this week and informed her that all outdoor tour operator licenses are accounted for, and so that's where I had that, why it's worded that way.
Uh-huh.
Now, it might be that the formal title of that license is outdoor
Horse tour operator.
space tour, outdoor space tour operator. I don't know. I guess we can look it up and see what the UDO says.
Yeah, I think it's outdoor horse tour operator.
Yeah, it looked like they were just trying to suggest a literal
A literal
space
space.
between the two words, outdoor
Yeah.
and tour.
Yeah.
I think that's what it was.
But I think there is one there, but it
It
just,
says
Looks like
out.
about a half a space.
It says
to me.
outdoor
Some letters
tour operator. That's what it says online. So maybe they didn't think there was a space because
Oh, okay.
there is no space. I think that's just trying to read the small print. So I think we're okay on that one.
Okay.
So it's designated in the UDO outdoor tour operator.
Yeah, I just Googled it and it came up outdoor tour operator reporting,
Okay.
which is just yeah, it doesn't say outdoor tour operators. There's nothing about outdoor space or
Okay.
anything
And I
like
think
that.
that's a space for the words.
I do too, but there is a space there.
Look, it doesn't look like a whole space though.
It looks a little
Short.
short there, but
Yeah.
it is. Okay, so then the county doesn't reference any other changes on page 7, but let's just go ahead and make sure. I want to make sure you all have any other comment or questions or agree those are facts that you found were relevant and
I know where that space looks small.
Yeah.
I think it's because these paragraphs are double justified.
Yeah,
And it's
right.
trying to fit it in
Right.
that line.
It's not an equal space on every
Yeah.
single line.
Yeah.
When you do a space on a
That's
justified
true.
format. Yeah.
I think that's the only issue with that.
okay. So if there's any, and of course, like I said, anything that was added from review of the record has the paragraph at the end showing you where it came from, unless it came directly from the UDO, because it obviously notes where it came from there. Which would bring us to page 8 and page 30 of your packet. To B, which is consistent with B, the size and type of items sold and nature of inventory on the premises. Including nature of inventory on the premises. And
They're asking to put an or between inside and outside.
Or, yeah.
and that came from Judge Tillett's letter that said, the type of storage, indoor, outdoor. But I can modify that to read just as the ordinance factor.
I don't see anything wrong with having the or in it. So I don't see anything wrong with
So
having the or in.
I guess I combined it with E because the information was, so if you look at, well, I'm looking at the ordinance and factor E, the nature and location of storage, outdoor display of merchandise, whether enclosed, open inside or outside, principal building. That's factor E. Because the next two was any processing done on the premises, including assembly, manufacturing, warehousing, shipping, distribution, dangerous, and then D is dangerous, hazardous, toxic. So I went to the next applicable section, which I thought was easier to combine than do it separately, but we can adjust it to that. Let me see. Inventory on the premises, period. And then I will move that on, let me just highlight that. Where did it go? Okay.
So in paragraph B, subparagraph I, they've underlined her car, for her car use. Appellant has 9 vehicles, including Jeep Wranglers, Jeep Gladiators, stored at her property for her car use.
Seems like that should be like.
Did we want to say,
transportation use.
or did we want to say, does that mean for her car rental use?
Well, this is what she's, isn't that what she said?
That probably was intended to be for her contended use, her proposed use, her purported use. You can make that whatever if you want to say for her car rental use.
What is the term that we're using to describe her operation? I think that would be the appropriate thing to put here.
Right, to put
Let's
that in
see.
there.
Yeah.
We've deemed that it's a rental use.
Earlier in the order, just give me a moment. I say that appellant alleges her use is not automotive sales and rentals, but instead is car sharing through reservations made with a company Turo. Let's see. I said appellant's purported use is what
Because she calls it vehicle sharing.
she calls it car sharing, she calls it peer-to-peer, she calls it
She calls it rental, she calls it everything in writing.
a little bit of everything. And so, I guess I would I have referenced it as her purported use.
I think that would be,
That'll work. I was saying she stated that was the use, not necessarily what we believe the use to be.
Yeah, initially she tried to say that it was all just personal stuff. You know, taking her daughters to school or whatever, you know.
And I can say of her purported use of quote unquote car sharing, which is how she described it. And I can put the quotes if you would like, if you want it that
yeah,
way.
that works.
Okay. So now that paragraph, I will say appellant has 9 vehicles, including Jeep Wranglers and Jeep Gladiators stored at her property for her purported use of, quote, car sharing, quote, part various surfaces.
Yeah, I think
Yeah,
that,
yeah,
I
that
think
sounds
that
better.
clarifies it.
Okay.
Work.
All right.
Yeah, and then on, in that same section, paragraph, I, there's a real small little edit down there in the last
Rentals.
line, rentals, that you might miss if you
Is that
Oh,
supposed
I
to be a
see.
comma, you think?
put that S in there real small.
Is that a comma, you think?
It's S.
That's an S to make
Oh,
it plural.
rentals.
Yeah, it should be automotive sales or rentals.
Sales
okay.
or
Yes, yeah,
rent.
yeah, good point.
You see it?
Yes, but my paragraphs were moved around, so I'm just trying to make sure that I'm EDO standards for automotive sale or rental applied automotive sales or rental.
Yeah, it should be sales or rentals, right?
Yeah.
Both pluralized.
Yep.
Got it. I found it. Just wanted to make sure I wasn't
paragraph 4, that rental also needs an S on the end. Use primarily involving the sales or rentals of automobiles.
Rental.
I might leave that one out, actually.
Yeah, yeah, I think
Yeah,
that-
I'd just leave it as rental, because you make it
I
plural
read
with
that
automotive.
twice. First it was fine, second
Yeah.
time it was like,
Yeah.
no, wait a minute.
Yeah.
Do you see my suffering over here?
Yeah. Fifth grade grammar all over again.
Oh my goodness,
Yeah,
I was
'cause
like,
Break a sweat doing this
I
one.
see Mrs. Harney in front of me all the time, every time I do that, because she would tell me all the time, just go with the first one. Just
Yeah.
stay with the first
In
one.
paragraph 4, I think it's being used as a verb. And in
Right.
paragraph 3, it's being used as a noun.
In
Or-
5, she has 2 more S's recommended there also.
Yeah, you do understand.
4, 5.
Very
Sale or
last.
rentals. Automotive sale or
Sale. Yes, I have that there. Let's see, there's no distinction. Numbers that are being marketed for sale or rent.
I don't know why she's just doing it on the one, though.
Let me just pull up
She's
the
just
actual
putting the-
formal
Should be sales on
word
the bottom one, too.
of the,
You know what I mean?
That's on
Right
rental
there.
instead of-
Sales, rentals, both.
I just want to make sure. Yes, it's automotive sales or rental. So the defined use is sales or rental, or is it rentals?
Automobile sales or rentals.
Rent with an S?
On both.
Yeah.
Yeah.
Use, yes.
Okay.
The UDO listed as automobile sales or rentals.
What,
Both S's?
what
Yeah.
section is that? I just want to make sure I put my eyes on it.
It's from chapter 4,
Mhm.
it's the summary use table.
There it is, okay.
4.1.
Yep, okay. All right, I'm with you. Well, then I will make those, I'm gonna make a note that I will go through and everywhere I note the,
Sale, search, rental.
no, but that might not even be right. Anywhere I use it as the term of art from the UDO, I will correct it to say sales and rentals.
Okay.
Or rentals.
Right, or rentals. It is rent, or,
Really.
all right, let me get back to chapter 10. So
my
I'm
gosh.
tracking with you on your changes. Alright. Here we go. All right, I'm back with you now.
On 6. Should that have an S on the end of occupations? Home occupation.
It depends.
We're talking about multiple ones. Could be
So-
accounting, could be, it's plural.
No, I think it depends on how it's defined in the UDO. Does it define it as home occupation or home occupations?
I will pull it up, but I do want to talk about this because that's one of the things referenced in Mr. Crook's letter was that home occupations were not considered or discussed, and they're not even the subject of the appeal. But the first hearing record does in fact, and I cite the section in the record where there was testimony by staff. They reference the home occupation standard and say this is another reason why our determination should be affirmed is because it's not a home occupation. Right. It's not this. It's not this. It's most similar to this. Mm-hmm. And so I disagree with that, but. And then let me look at home occupation.
Yeah, so
What,
let's see why I picked that up, because they could argue it's a home occupation.
4.3. I'm just going to get to that section and make sure that we have it properly identified. 4.3.3. L A B. S, home occupations with an S on the end.
Okay, well then that should be are defined, not is defined. Right?
No, because it's
no.
a category.
It's a category.
Okay.
Yeah, home occupations is a category. It doesn't sound right,
It
but
doesn't
that's,
I
sound
know.
right. No, it doesn't.
I know.
Yeah.
Right at all. Or it should be home
Well, it said
occupations are defined as.
further in the paragraph says home
but
occupations
home
are permitted.
occupations is the
singular
category.
thing.
It's a
That's the
singular category.
category,
Yeah.
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 You see?
Yeah, see, I remember
Paragraph,
something
home
from
occupations
11th grade
are
English.
permitted.
You remember a whole lot from there, because it's like, wow.
But then it's per home occupation in the last sentence.
Well,
really
because
confusing.
I'm not identifying that as the category, but because that is referencing a singular home occupation, not
Right.
necessarily the category term of art home occupations.
I agree. Next one.
But I did, and I guess I didn't, I don't see where I cited the home occupations on
On the
the record
From the record,
page.
yeah, I don't see anything on that.
And I just want to make sure, I want to note it. Okay, lovely. Page 62. UDO, and this is a quote, it is continued on the attached page. UDO section 4.3.3 L regulates home occupations. And there it goes on for two pages about home occupations. So from page 62 to 63. So for the record, it was discussed. Okay, and then the type, let's make sure. So now we're on C, which is not C because I jumped around. So C is any processing done. So you would like me to add these and say the board determined that's not relevant. Is that right?
Yeah.
Okay. Board determined this factor was not applicable.
I would probably leave it as we use the term relevant, right?
Okay. Was not.
Found to be irrelevant.
All right. So then that takes us to, and I'll add that in. I'm not going to type it now, but I can add it in and for chair's review. D, the same thing. That's not there, but the toxic impact that was found not to be applicable or relevant, excuse me. E, the nature, location, storage, outdoor display of merchandise, whether enclosed, open, inside, outside, principal building, predominant type uses, types of items stored. I combined that one with B originally, so I will move that down. And then, did you want me to just reference section B above? Does that make sense? So it talks about the nature and location of storage or display of merchandise, and B talks about the size and type of items sold and the nature of inventory on the premises. And so because of this type of use, those two factors are very similar to.
But are they separate factors in the
They're
UDO?
separate factors in the UDO. So I separated it, but what I'm saying is, do you want me to reference under this subparagraph, say the board found this relevant, see subparagraph B? Or do you want me just to repeat all the same things again? Does that make sense? Or do you have separate or additional findings for that separate from
One relates to the size and nature, type, size, and nature of buildings and structures, and the other one,
Nope, you're looking at F, and that's not, look at,
Looks like C to me.
so if you look at B on your order, which is
Yeah.
page 8,
Yeah.
page 30,
Right.
the size and type of items sold and nature of inventory on the premises.
and then the and is actually, factor E in the ordinance. So after the and there, I combine them
Oh, okay.
in your proposed order because the content relevant to both those factors were similar, given the use. So,
Yeah, I think that's fine to say see paragraph B.
so unless you want to break them out, repeat them, or you find that it is different, which we can do, or substantially different enough that the same information wouldn't be applicable to both factors, we can add to, subtract, if there's anything else you want to add.
I don't really think there's a need to repeat the entire thing.
No, I don't either. I think what's here in paragraph C,
Subparagraph B.
no, and what's in C for the size and nature of the buildings and structures.
I guess maybe B and C, because it says the type and display of merchandise, which is also B, right?
It's like they're kind of
Which is the
commingled.
items in the inventory nature, the size and type of items sold and the nature of inventory on the premises talks about the vehicles, right? And they're just,
Right, that talks about the vehicles. I thought the other one talks about the actual
buildings and
buildings and the
structures.
structures,
The nature of the buildings.
which are two different things. But I don't know that there's anything else that needs to be said about the nature of the buildings and structures. It's a single family dwelling,
Yeah.
and
There are no other apparent structures.
right. Okay.
yeah, I would just leave it.
Yeah.
Yep.
I think it should be
Agreed.
separate. Yeah. Leave it the way it is.
All right. Well, and I think we're talking about two different things. And I'm not trying to be difficult, so I just want to make sure that I'm clear because I'm trying to draft this as you. So the ordinance has subparagraph A is the volume, type, and sales, retail, wholesale, et cetera, which we did, right? So that's A, and that matches A on our order. B is the size and type of items sold and nature of inventory on the premises. C was any processing done on the premises, including assembly, manufacturing, warehousing, shipping, or distribution. D is any dangerous, hazardous, toxic, or explosive materials. And E, which is where we are, we're not to the type and size and nature of buildings yet. E is the nature and location of storage or outdoor display of merchandise, whether enclosed, open, inside or outside inside or outside the principal building, predominant types of items stored. And so that was my question, is that factor E really the same information from B, which is talking about the type of inventory on the premises, where we're talking about the display of the vehicles, and from what is going to be F, the type, size, nature of buildings. Both of the information under those factors are relevant to address E. Does that make sense?
I would just list E, and I would list what E is, and I would say C,
Reference the other paragraphs? Is
Yeah,
that fine?
there you go.
Okay.
Yeah.
and just do it that way.
All right, I will reference those two paragraphs. So then that brings us to the type, size, and nature of buildings and structures, which those two subparagraphs, which is F. So that's properly now titled as F.
Right.
Okay, G is is not properly noted. The next one is not transportation requirements. It's going to be in the ordinance, after the type, size, and nature of buildings, it's the number and density of employees or customers per unit area of site in relation to business hours and employment shifts. And I need to look at the minutes to see if there was anything else related to that. Or if anyone had anything proposed for that.
Do we find that to be not relevant?
Oh, good.
Not relevant to what?
To car rental business. So it's not, the number of employees that you have are not relevant to whether you're operating a car rental business or not. You could have one employee doing a car rental business. It's still a car rental business.
We're no employees, just her, you know. So.
Right.
Okay.
Yeah, we went through all those factors to decide whether
for my
some of them
minutes.
were not
Are you
relevant.
looking at
And we should just list it and say, you know,
Yes.
Yeah.
Right,
considering the number of employees, it doesn't matter if you had one or
Right.
many.
right.
It could still be a car rental business.
Right.
G, number of employees are not relevant because UDO does not define the number of employees, but only an activity. The customers were coming there. Since Ms. Young testified, customers do come to her house.
Yeah,
That's what you found. Okay,
Yeah.
so I'll just add that from the minutes that
That'll
you
work.
found
Yeah.
regarding that.
That's real specific.
yeah. I knew we talked about it.
Yeah.
It's only been 2 years, so I'm sure we talked about everything.
Yeah, we did.
There is no true way to be concise and then have brevity in what you write.
And be complete.
You know what I mean? It's like, it's not possible, have them both at the same time.
All right, H, G. Okay, H, now we're on transportation requirements, including the modal split for people and freight, volume, type, characteristic of traffic generation to and from the site.
D becomes H, right?
Correct, that's right. And those the information's under there. I added the trip count, because this board repeatedly talked about the trip count from the exhibits that were received in the record on the first round, and the number of trips, and then the new number of trips.
Yeah, I think
But
that's really relevant.
if there's anything else you want me to add to that section or change or modify.
I don't think there was anything additional to that.
You-
Did you have in there, did you have that, this is what they said at the last meeting, this is relevant, Ms. Turner testified that rentals were driving to and from the house. This creates traffic generation. That's what the board said in J,
Okay,
on H.
I will add.
I was just speaking to that point, Sheree, as well. I was thinking the same thing about subparagraph 3 there. It says will be dropped off for the rental, and you could add to that at the residence or at her residence, I think, in the same way, and cover
Yep.
that as well. And then reference that during the testimony on that item 3 rather than writing something else in there again. Did you get that, Lauren?
I did not, I'm sorry.
Okay, under 3, it says appellant testified customers would walk, drive, or be dropped off for the rental at her residence. I think I would add, and then I would reference the statement that she made during testimony that Sheree had just said.
That Jenny Turner said that.
Ms. Turner.
The staff said that. Okay. Yep, I'll add I made a note, add traffic from minutes.
Because right, when you read it, it doesn't really tell you where they were dropped off, just says they were dropped off.
I agree.
And that was relevant.
Yeah.
Absolutely. Okay. Let's see.
We're on I now.
Yeah, we should be on I.
Which used to be E.
I is, let's make sure, trip purposes and whether, it says I in the ordinance, trip purposes and whether trip purposes can be shared by other use types on the site. And from the minutes, I had, that's where I got these two, this information. But of course, if you have other based on your review of the record, your attendance of hearings, if you have other findings regarding trips and the purpose of trips, let me know.
So the characteristic, the standard is this the full verbiage of what it says?
It
Trip
says,
purposes and whether trip purposes can be shared by other use types on the site?
correct. That's what it says verbatim.
Because I think, the trip purposes for the use of the rental vehicles, I think was pretty cut and dry, but she did mention that she made personal use of those vehicles too.
Right.
And I'm just wondering if that needs to be mentioned in this part or not. Not that it changes our understanding of the rental business, or do we just want to stick to the facts surrounding the factors as they apply to whether or not it's a rental business, or we considered it a rental business?
Well,
So, I'm not trying to cut you off.
the trips are counted if you look in H or D above 2, and it says it's from the Turo profile, increasing from 23 to 80. So even the argument on the basis of it was personal use or otherwise, you're not tracking your personal trips on Turo.
Yeah, but it says
No, but it could-
trip purposes and whether trip purposes can be shared by other use types on the site.
Right, yeah, and I agree with
There's a question of whether the operative word is use types. So is her personal use of the vehicle even something that would be considered another use type under the UDO, or that's just not relevant if it's not a use type, a defined use type?
So I think that her personal use of the vehicles is coincidental to the residential use of the premises and the residential zoning of the premises. So if you look at the purpose and intent statements of the different districts in Section 10, which is fleshed out in your order, it talks about, in that section, it talks about that that is the word coming to my mind right now is coincidental use, but almost like an accessory use to residential, which is your own personal use and parking of your personal vehicles. But we can add something that says,
That would be more of
You
an
know,
inherent use.
right, inherent use. That's
Now that I read through it again, I don't know that we need to add anything to it because this talks about trip purposes and whether trip purposes can be shared by other use types on the site. And I don't think her personal uses would be considered a use type.
Yeah, I see what
And
you're
then
saying.
in subparagraph 2, E2, it defines what we're talking about here. It says the trip purposes for this use were the rental of vehicles.
Right.
So, I think I'm good with
Yeah,
it.
the
way it
trip
is.
purpose for a rental is gonna be different than a trip purpose for inherent use of your
Right.
vehicles from your property elsewhere.
Right.
Or to there.
okay. Which brings us to parking requirements, turnover and generation ratio, the number of spaces required per unit area or activity. What do the minutes say about that? Parking requirements, turnover and generation. That's the section that I added, the portion about, I don't want to operate in Duck because I want to operate in
Right.
Corolla
Be
because
close
it's.
by, sure.
And that was in response to a question. It can go under the other additional considerations. It doesn't have to go there.
Can we, on that one, can we clarify, it says appellant operates a business in the town of Duck where she could rent Jeeps, but she chooses to store the Jeeps
It
in
needs to be
and rent
cleaned up.
from, could we put from her residence in Corolla?
There you go.
Well, there was
What did
other-
they
Well,
say?
their primary
At the
residence.
last meeting
Yeah.
in June, that one, they found it not relevant.
Okay.
That was the board's findings. in
Although
June.
she did mention that, and there was evidence that rentals were being parked in a parking lot other than her residence as well.
So I guess I would you found that parking requirements, turnover and generation ratio, number of space required per unit area or activity was not relevant. So if you find that this subparagraph about her statement about where she rents it from and why is relevant to the overall consideration, we can just move it to the additional factors, right? So that list is not exhaustive, it's clear in the ordinance. So we can just move that down
And that-
such
that-
that there's
We should
no,
do that, yes.
That shows
Agreed.
intent to
I think-
use it nearer to the home.
okay, so I will move that.
Because I think it's very relevant whether the fact that she has a business in Duck and could rent the Jeeps from there. And chooses not to.
So I will add that.
And maybe can't. or
Well,
whatever the
wouldn't
rules
tell
are
us what
for
the
where
business
she
was.
rents.
You know,
Yeah, she wouldn't tell us what the business is.
Right.
Well, and that, you know,
I guess that's a
And that's her
prerogative.
business, yeah, but
Well,
I
it's
get
in Dare
that, but
County, so it ain't
doesn't
our
mean-
business.
That's right.
Yeah, right. That's it, town of Duck.
Yeah, that's right.
It's only 12 miles from her house.
okay, so I'll move that down to the additional factor section, and then I will make, and again, certainly, I will clean that up and say that the board didn't find that specifically relevant.
But I like that determination. Would defeat the purpose of her customers. Point being
I
is she's
quoted
admitting
it
she has
from-
customers, you know.
This was the, that was in response to, I believe, a question by Troy.
Yeah, I asked a lot of questions that night, didn't I?
There were lots of questions. Yes.
Yeah, there were.
There were. Okay, and then that takes us to the amount and nature of any nuisances generated on the premises. I need to add that in. Because I skipped over it because it was, is that right, Sheree? It was,
The finding on that was the board's finding is possibly not relevant. Ms. Womble will review the record to make sure this was not considered previously.
The only way that I think that we could consider that would have been if we could have considered the testimony of the neighbors in the hearing
Correct.
before last that complained about it, but I don't know. Because that was, I think that was part of the issue with the neighbor speaking in the public
that's,
hearing portion, and then
And she said she couldn't.
that's right.
cross-examine.
When I look
Right.
back at the record from the transcription and your deliberation and in your questions and to the parties, you don't reference that and you don't, and you properly did not reference the public comment, which is why at the beginning of the order I specifically put in that the board did not, in the procedural history, I think. Where did it go? I added a pair, oh, here it is. It's finding of fact number 1. Each witness appearing before the board was duly sworn and subject to cross-examination. The board did not consider any of the June 16, 2022 public comment in this matter.
Yep.
And that's the only place where any nuisance information was presented to us, and we never considered it.
Correct, and you never, and even to this point, you didn't, again, there was nothing presented about that, and you didn't find that there was no information to make it applicable or that you could gather from the record, I think, to fit
Even
in
though
there.
ironically, that's probably what started this whole thing, was the complaint to the county, about it, but
Well,
They just have to call those people as witnesses or,
That's right.
testimony, and then we'd have that, but we don't.
yeah, but it's not relative to what we're
No,
trying to.
you got
then
9,
you
10,
can always
11
come
other
into it.
points that you talk about. It's like, at that point, it's dead. We don't really need that as well.
Either it's an
I
allowable
think
use
that's
or
what
it's
we
not.
decided, that we
Right.
really didn't need that,
Yeah,
because then you get into personal animosities, and that could be open up a
Right.
can of worms.
Right.
We were going on UDO.
yep, the next one is the, factor L, any public utility requirements for serving the proposed use, water supply, wastewater, et cetera, I believe that was found not relevant. And so I did not add it, but I will note it and, make sure that it's referenced so that it's numbered clearly. And
So you're
then-
including the elements that we didn't find relevant. Okay, yeah, that's a smart move.
And then M is the impact on adjacent lands created by the proposed use, which should not be greater than the other use types allowed in the zoning district. This is, and that will be now M. And you see where I reference the minutes, I put page 5, but that was kind of the draft minutes at the time that I was using, but it's in the minutes from, if it says minutes, it's from the last meeting, the June 2024 meeting. And then from there, you see that this references the sections of the UDO that was referenced by staff, and also the intent statements within the Article Chapter 10, which is part of the instructions for 10.4.1.2 D2 to do all of the things, and that's where that comes from. And this was, again, part of your, based on part of your discussion about reading it in its entirety, making sure you read the purpose and intent of the different sections. You guys asked some questions about the purpose and intent of different zoning districts, and there was testimony by staff regarding that as well. And then, of course, the UDO just generally referenced. And then we have the next section, which will be, I think it's marked as your, let's see. Okay, which will be your 35, page 33 of the addenda packet. She says format. I think that is actually, the 36 is actually lined up where it's supposed to be, but I can pop it out a little bit just so it's easier to catch with your eye. I agree, it is kind of,
It's only
difficult.
like 5 spaces right of where it ought to be.
Yeah. But I'll adjust that just so it reads a little easier. It says additional factors relevant included. Do you want to use the word factors? Do you want to use relevant considerations? Additional relevant considerations included? How do you want to?
How do we refer to it in the beginning? Is it factors? Is it how we?
So it says that the ordinance says that all relevant characteristics of the unlisted use, including but not limited to, so we can change it to the relevant characteristics, additional relevant characteristics.
Yeah, I'd like to keep
Yeah.
it consistent with what
Okay.
the UDO
Sounds like
defines
but
it
yeah, the
as.
UDO says that.
So that'll now read additional relevant characteristics include, and then it'll go from there. And then again, these are just based on what was already in the order. Anything that was added, I referenced the site where you could find it and review it. And I assume at this point you have, and if you agree, it's fine. If not, you're going to tell me.
You know, I after the last hearing, I went back and I did some research on Turo, because one of the things that she said was that the Turo company had won a court case in California that said that they were not a car rental business, they were a peer-to-peer vehicle sharing business. So I went back and I read that court case, and there's a nuance to that. Yeah, the court determined that Turo, the company Turo, is not a rental business because they don't physically rent the vehicles. They just create the platform where the renters use the platform to rent. So the renters are actually the ones that are renting the vehicles, and the Turo company's not doing it. They just have like
They're
the
just a
website
middleman.
and the
It's
the format.
administrators.
Right.
Yeah.
Right.
So they're not a rental company, but that doesn't mean that the individual
Who was renting the
people that are
vehicle
renting
are.
vehicles, they're not.
Good detective work there. Troy.
Yeah, I thought that was
But
interesting.
Yeah,
I was
it
gonna say,
is.
but for the record, that was not part of your consideration.
Yeah, no, it was
This
not.
is
It was
all
not.
Post.
It was not. But I do know that was something that she mentioned in her testimony that Turo was deemed to not be a rental vehicle company by the court. So.
This case is not about Turo, right?
Right. That's right. That's right.
And this is where, so to this section's where I moved that portion about renting from renting from Duck versus Corolla.
Yeah.
So I just added that characteristic to this section.
Yep.
Okay. And then let's see. Our other ones are just little, okay, I think that's everything from the county changes. So in regards to, are there any other changes or additions or facts that you found from your review that you found was important or relevant, or a fact that you felt necessary to have added to the order?
I don't know. I think it's pretty complete, pretty thorough.
Well, not to mention the fact that we went over all 13 of those individually.
Exactly, Stephen.
Independently, voted on every single one of them individually.
And what I'll do is, because when I don't know that I had the final draft of minutes before, I had a draft version, and I'll just confirm that I added everything from those minutes to each factor. That if you made any additional findings to what I already added in there, just to make sure. I think I did at this point, but after the one we added something, I'll just go back and double check that for you. I know I had a version, and I just want to make sure that I didn't miss anything. So,
It's in the packet.
yep.
Right.
Oh, I have it. And you sent me one before when I was drafting it. I just want to make sure that I didn't. Now that they added something else, I just want to make sure I did not miss anything.
But it's not verbatim, I just want to say that.
I know it's not.
Okay.
I know it's not. It's okay.
So the home occupation standards were from not this most recent hearing, but from
The one before.
an earlier.
That's right.
Yeah.
And that's been transcribed, so.
Okay.
It's not allowed. Yeah, that's not a use that's allowed
Yeah.
in her
As a home
zoning.
occupation.
That's not
Yeah.
allowed as a home occupation.
But in the lawyer's letter, he cited that as an example that I guess maybe it wasn't discussed in the last hearing, but if it's supported in the record previous, then I think it's valid.
I recall it being discussed in the last one,
Home occupancy?
because we discussed whether she lived there or whether it was a rental home.
That's when she said, you can rent out your primary residence. Anybody can do that. And I wanted to ask her if her kids were going to school here or whether they were going someplace else. But I didn't want to get too angry,
She
and I didn't
doesn't
want to
live
get
at the
angry.
house. She doesn't,
She doesn't?
no, she rents it out. She rents it out every time we go there. I put up a sign, and her cleaner, there's people from New York there. Every time we've been there, it's people
Is it
out
Hampton?
of state.
Is that what you're saying, Hampton?
Yeah, she doesn't live there. She rents it out.
She, her testimony was that, and it's one of the findings in here, is that she moves out in May. She moved out in May of 22 to, do some renovations I think it was May, to do some renovations and to rent it out. That she rents it out during the peak season, and then she lives in it in the winter, is what
So
I
it's still considered her primary residence, though, right? Maybe,
I
I don't know.
assume so, but for
Yeah, I don't-
purposes of the notice of violation,
Yeah, I
she
don't
was
think-
living there at the time the notice of violation was issued.
Yeah.
So,
I mean, it still wouldn't really matter in this case. It's still a residential, it's SFO
exactly, it's
district.
still an
and-
SFO.
Yeah.
In fact, part of her testimony was that, because there was a question about the number of vehicles parked on the,
Right.
you know, and what's the permitted parking for residential, and she said actually that they fall under the vacation rental expansion for parking because she does rent her house out. So she actually has expanded parking because, like the number of vehicles you can have on site at one time. But,
Yeah, she actually lives in Duck,
so,
Grass. 1177 Duck Road. So that's what she lists as her.
That's where she
That's where her
lives. That's
taxes go to.
Sandcastles for kids. It's
She's
a
got
little dress
Suite
shop.
41.
Is that what it is?
That's what she lists.
I just looked it up on the internet.
On her taxes.
That's what I was gonna do.
but none of that's relevant to this.
Again, yeah.
Then I would guess.
And wasn't, you know, we have, although there
now
is
we
here,
know,
it
now we
says
get
that
it.
she refused to testify about what business was located at 1177 Duck Road, Suite 41, Duck, North Carolina. That is in here, and because that is what occurred, you did ask, and she refused to testify about what she was doing at that location.
Right.
So, anyway. Is there anything else? Now, my last,
She sounds like an IRS agent's wonderful dream come true.
well, so in regards to the order and these changes that you've approved tonight, are you comfortable with me making those final changes and submitting it for the chair to review to confirm that those changes were made? Or do you want me to bring it back to the full board again?
No.
No,
Okay.
We don't need that. I believe that falls on the chairman.
Yeah.
We're gonna miss out on that big $50.
I just wanted to make sure that you were, since we've made such a detailed review about the changes and documented those, if there was anything else, I'll be happy to bring it back, but I think the chair can review.
So you
You'd
think you
like
covered
us
what he's got in
to
his
have
list?
a vote on accepting these?
As amended tonight, yes, I think you should vote to approve
idea.
the
That way we have
draft.
it on
We
record that
need
we all
to
agree on.
navigate, because we have, Shay was here for the actual, this hearing. You were here,
He will.
I was here
the
for everything except for the
last
last
The
one.
hearing.
last one,
Yeah.
yeah.
Were you here for the last one? Yeah, you
It was,
we only have
here
We only had four.
you only had
for
4.
everything except for the last one,
And
right?
that might be I saw somewhere else where it showed unanimous 5-0.
I thought it said unanimous 4-0.
The last hearing was 4-0.
It says
The
5-0,
one
but it should
before
be
was-
4-0.
Right.
Yep, it should be 4-0,
Just
that's
forward
right.
it then.
It was 5 the last
Right.
time. So I'll fix that, thank you.
Yeah, 4 instead of 5.
I don't know the
let's say
answer to
4.
who should vote on that. I think it should,
I'm gonna suggest that everybody vote on it who was participated in it in some form or fashion. Because then you
I
have
was
the
gonna
accept-
say that, I mean, I don't know that any, like, maybe we should take 2 votes to,
For
so,
all, perhaps.
huh? Yeah, only 5 members can vote, and so I think that the members who participated in the first hearing can vote that, yes, they feel like this order reflects what they had in the first hearing, and then those who participated in the second hearing can vote regarding the portions of it that are from the
Yeah, that
second
was
hearing.
us 4 here.
So I don't, because
Shay
I
to
don't
me.
really know, I
was-
don't know
it
the
was-
answer, but I don't know that we're gonna get, that there's gonna be
Steven.
an issue about that. I mean,
Mr.
generally,
Kane
the
and-
order would always just go to the chair and the chair
Yeah,
would adopt
right.
the order. I don't know that a vote's even required, but for record-keeping purposes, and because it's a little unique, we had the remand from one portion of the board's
Right.
order, and then a second hearing on, and so from what other members heard, and you're finding, the board is one complete, constant entity, you
Well,
know?
that's what I was gonna say. If we have a quorum, are we an entity?
We'll do whatever you want us to do as far as the
Yeah.
legal
it
aspect
stronger.
of,
Yeah, would it not be any
vote.
different than if
I don't
the,
want him to send it back.
yeah, would it not be any different if you had a remand order in November and then
The
the
board
board didn't get
changed.
back to it
I
until
know,
January?
that's what I was
you got
thinking
new
about.
New members and
I
they just.
think that, and then the alternates only vote if the regular members are not here. So I think we have the regular members vote, and we have the discussion from Shay, who was here in that, because you can converse. Let's just have the regular members vote, and I think that's
being that-
appropriate. But I think that just for the record keeping purposes, Shay, is there anything that you would like to add, or just, just from your review, you did give some comment tonight about that. Is there anything else that you have to say, or that you would contend would need to be changed based on that last hearing?
No, I'm perfectly fine with what you've came to the conclusion of tonight and allowing Mr. Craddock to review it final.
Okay. All right, so then I think that you can vote to approve the draft as amended tonight, and have him bring it back. Although I don't know that the vote's even required, we'll go ahead and do it for the record.
Yeah, why not?
That's right.
That's
All
a
right.
question they can't bring up then.
in that case, can I have a motion to accept the order as amended?
I so move.
Is there a second? All right, is there any discussion? All those in favor of
Yeah.
accepting the order as amended, say aye.
Aye.
All opposed, say nay. Motion carries unanimously.
All right. I will get the updated version to the chair for his final review and signature.
So you think that addresses everything in his letter? Well, yeah, no,
the
because
best
there
of-
aren't anything in there.
To the best of our ability, I believe that we've, addressed at least the two concerns that he had.
Right. Home occupation.
Which I noted, and I'll make sure that, kind of for the record, just because we know this is going back up, I will, because I added the reference for that section about where it was in the record, I'll do another draft copy for the chair to approve that leaves those record references in. Once you approve, I'll send you a clean copy, which will take out those references. That will be the one that's signed. So that way we have all the draft versions in the record. So when it goes up, it can be easily seen what was relied on.
Yeah, his first thing was the 10 points, which we did. We did all 13. So. Okay.
Yeah, I'm very happy with how it was all handled in every one that we have heard so far, and the order itself is very concise, it's right to the point. I really appreciate the verbatim transcript. That is a great thing. It's too bad we don't have that all the time, but I know it costs
Yeah.
to do that. But anyway, I'm glad we did well on that, and the four that were here on this last one, they had a lot to listen and analyze, and all 13 of those points. Were there any other announcements? Hearing none, I'll take a motion for adjournment.
Motion to adjourn.
Any second?
I'll second that.
All those in favor say aye.
Aye.
Motion is approved.